All right, so we'll be covering chapter 5 today. We are still talking about the law of torts. So last class, Monday, we started the law of torts. I did provide you a definition of what torts are and the main objective. What is the main objective of the law of torts? Does anyone remember? What is the main purpose of the law of torts?
Anyone who suffer from any damage.
Okay, what will they do? What can they do? What does the law of
They can get
torts?
compensation.
Yes, that's correct. So yes, for victims of damages, losses, injuries, through the law of torts, victims can be compensated, can seek compensation. There are other remedies available too, but still compensation is the main one. And we differentiated torts from criminal offense. So a tort is not a criminal offense. Criminal offense is pursued by the government, by the prosecutor, even though one conduct may be both a tort and a criminal offense, such as the criminal offense of theft and the tort. Does anyone remember the equivalent? What is the tort for the criminal offense of theft?
Conversation.
Almost there. Conversion. Exactly. So when we are victims of theft, we'll report to the police, but then we will sue to be compensated on our loss. We will sue for the tort of conversion. Okay, so yes, tort is seeking compensation. Criminal offense is when the government protects society as a whole. There are different proceedings. And we also saw that a tort is different from a breach of contract. Even though a breach of contract may cause losses, damages to one of the contracting parties, a breach of contract is not necessarily a wrongdoing, a social wrongdoing. It's usually poor performance or no performance at all, but it's different from tort. So those things are important. Now, I told you that we have intentional torts, and we've gone through many of them. So the intentional torts, they are more concerned about the intent to act wrongfully, not the intent on the harm, even though the harm is relevant for compensation. And then we have unintentional torts, careless act, careless conduct, which in my view is the most common one, because in most situations we suffer damages, losses, injuries, because others have acted wrongfully in a careless way, unintentionally. So that's what we're going to see today when we talk about negligence. So negligence is the unintentional tort. Now, we also looked at the concept of vicarious liability. So vicarious liability is when one is liable for the wrongful conduct of another. Both parties will be liable. The party or the person who actually acted wrongfully, but also the other party, even though they were not at fault, they were not acting wrongfully. So that's vicarious liability. Does anyone remember some examples I gave or some situations in which vicarious liability is more common?
At employee workplace?
Employment and relationship.
Employment relationship.
Exactly, right. So when an
Oh, doctor and patient.
Doctor and patient, the doctor and patient.
No. It's like assault and battery. This doctor will be better.
Yeah, no, but the relationship about doctor and patient is a different one.
Yeah, it's a employment relationship.
Here, the relationship is employment relationship. So an employee like myself, if I act wrongfully and I cause you damages or someone damages while I am in the course of work. So let's say I share a file with you and the file is infected with a virus and it infects your laptop or your PC, and then you have losses, then you can sue both BCAT and myself. It's not that you choose who you will sue. You can sue both, and you should sue both. Why? Because your chances to be compensated will actually be higher. Remember that I told you BCATs is slightly richer than I am. So yes, you're better off by suing BCAT too. Then we went through, so vicarious liability is an important concept. Because yes, as an employee, you may be attracting liability to your employer, or as an employer, as a business owner, your employees may be attracting liability to you. So keep that in mind, very important. Now, we went through several torts. I won't reveal them, but just mentioning assault, battery, those are torts, intentional torts to people, trespass to people. Then we saw trespass to land. We saw trespass to chattels. Remember, chattels mean goods, the same thing. So lawyers like to complicate a bit more. Trespass to chattel, conversion, debt new, malicious prosecution, false imprisonment, private nuisance, defamation, injurious falsehood or product defamation. And then we went through other torts more related to business, such as deceit, intimidation, unlawful means tort with economic relations, passing off, misuse of confidential information. And we also saw two torts on privacy. The two main ones, they are invasion of privacy, also spoliation, the tort of spoliation, and the intrusion upon seclusion, that tort that is recognized in Ontario and in the US. So that's briefly what we saw when we started looking at torts. And today we're going to finish the law of torts. I did tell you that in law school we study torts for at least one term, and here we're just spending 2-3 hours on it. So it's very, very basic. In law school we study more case law, more in detail the concepts, the requirements, remedies, etc. So today we'll start by looking at the unintentional torts, which is called negligence. And then after that, we're going to look at several types of liability, such as occupier's liability, strict liability, product liability, professional liability. And we are going to end the chapter with insurance. We're going to look at insurance. So let's start on negligence, this inadvertent, unintentional, careless conduct. So when you are driving and texting at the same time, you are careless. If I share a file with you and I didn't scan the file before and the file was infected, caused you harm, I was careless. If I am mopping the floor, when someone is mopping the floor at a restaurant, at a place, what do they do? What is a diligent thing to do?
Wet floor sign.
Sorry, can you say again?
Wet floor sign.
Yes, wet floor sign. So if they're mopping the floor and they fail to have the wet floor sign, they are negligent, they are careless. So those are examples in situations like myself. You know, I teach. When I'm speaking, I'm using my hands, I'm moving my hands. What if accidentally I hit your laptop? It falls, it's broken. I hit your screen, it's broken. Well, not intentional, but out of a careless act, out of a careless conduct. So that's what negligence is. That's what the unintentional tort is. And there's no list of several types of unintentional torts. No, there's just one unintentional tort, which is negligence. So this negligent act is this careless conduct and causes damages, causes an injury, a loss. So remember that for the intentional torts, the loss, the harm, is just relevant for compensation. Is not relevant for the conduct, the wrongful conduct. Now, here, for negligence, an injury, a loss, they are required. If there's no loss, there's no negligence tort. So I'll move forward and I'll show you very in big letters. So no injury, and when I say injury, I'm also saying damages, loss to property, loss to people. So no injury, no loss, no damage, no negligence claim. And now think about this. If I'm mopping the floor and I forgot to have the wet floor sign. But if no one is injured, was I negligent? Yes, I was. Can someone sue me? No, they cannot, because no one suffered damage. No one suffered an injury. Now, for those who drive, you have eventually drove and texted at the same time. So you were negligent. But if you haven't caused any accident, if you haven't caused any loss, injury to others, no negligence tort. Okay, so here, damage, this loss, injury, they are required. Now, not only damage, not only the loss, but there are other things that are required too. And they are known as the 4 required elements. Now, one we already know, which is the damage, the D, but there's the required element of duty of care. That duty has to be breached, so that's why breach of the duty, and then causation. Causation is the link, the physical link about the wrongful conduct, about the careless conduct, and the damage and the loss. So it is, for study purposes, it is what we call the ABCD. The ABCD because it's A, duty of care, and then that duty is breached. So B, breach of duty, causation, C, and then damage, the D. Now we have to look at those 4 requirements, because if we want to be successful in a negligence tort, we need to meet, or we need to prove, we need to establish all those 4 required elements. So let's start with the first one. The first one is a duty of care. So a duty of care must exist. Well, I'll tell you that this is the simplest element. And by the way, it's rarely challenged in court. Why? Because courts, historically, they have already established that in most life situations, there is a duty of care. Most life situations, there is a duty of care. However, if we want to know what this duty of care means, how courts established the duty of care in most life situations, then we apply what is called this reasonable foreseeability test. And it's a simple test. It's a simple question. So the question is, would it be reasonably foreseeable that by our conduct we can cause harm to others? Or can we reasonably anticipate that someone may be harmed by our conduct? If the answer is yes, it means there is a duty of care. Now, let's think about the examples I gave you. When I share a file, when an instructor shares a file with the students, can we reasonably anticipate that the sharing of the file may cause damage, losses to students? What do you think?
No.
Yes.
Yes, the answer is yes. So for those who are still there paying attention, the answer is yes, because if the file is infected, there may be loss. So the simple act of sharing a file may cause harm to others. Now, if I'm mopping the floor with or without the sign, the question here is not the sign, but by mopping the floor, can we anticipate that people may be harmed because the floor is wet?
Yes.
Yeah.
Yeah.
Yes. When we are driving, is it reasonably foreseeable that by driving we may cause harm or injury to other drivers, to their passengers, to our own passengers, to property?
Yes. Yeah.
Yes. So you see, most life situations, the answer will be yes. So whatever we do in life, most things we do in life, we can anticipate or reasonably anticipate that others may be harmed by our conduct. So that's why this required element is rarely challenged in court. Because most situations, people may be harmed from what we are doing. If I'm just, let's say, I don't know, I'm driving my electric scooter. Can I hit someone by driving a scooter? Can I harm someone? Yes, I can. So you can think about any or most situations in your lives. The answer will be yes. So that's why this duty of care is usually there. And because it's usually there, very rarely parties will, or the defendant will challenge this requirement in court. Now, what is really challenged, and I'll get back to this in a minute, what is really challenged is the breach of that duty. So now we have established that there's a duty in most life situations. Now, how do we breach our duty? Well, breaching the duty means we have acted below the standard of care. And what is the standard of care? Well, the standard of care is what a prudent person, a reasonable person, that's why it's called the reasonable person test, what a reasonable person would have done in that situation. So now let's think about the same situations. A reasonable instructor, a reasonable prudent instructor would have scanned the file before sharing with the students. So if I have not scanned, I breached my duty. I acted below the standard of care. A driver, a prudent, reasonable driver, they would not drive and text at the same time. So if a driver drove and texted at the same time, they have breached their duty. A cleaner mopping the floor, a prudent, a reasonable cleaner would have put out the wet floor sign. If the cleaner did not, the cleaner breached their duty. Can you understand what this standard of care is? So we compare the standard of care with another similar person, not a perfect person, not an average person, but a similar one. A cleaner with a cleaner, instructor with an instructor, a driver with a driver. Does it make sense?
Yes.
All right, so that's breaching the standard of care. So now we know that in most situations there's a duty of care. Now, whether the defendant breached their duty or not, we'll have to apply the reasonable person test. Now, if they have breached their duty, then there's still a need for a loss, as I mentioned before. So I may have shared a file with you. I breached my duty because I didn't scan the file, but the file did not cause any loss to you. The file had no virus eventually. I mopped the floor. I didn't put out the sign, but no one got injured. So it means that even though there's a duty, the duty was breached, there has to be damage or injury or loss. And that damage or injury or loss has to be directly related to my negligent conduct. In other words, I shared a file with you, it was infected, I breached my duty. However, your loss was because you downloaded a different file. So if I can prove in court that my file, even though I was negligent, was not the one causing you loss in your laptop, but it was the file you downloaded on yourself, there's no causation. I am out. So my wrongful conduct that was below the standard of care needs to be the one that caused the plaintiff or the victim the injury, the loss. If I'm mopping the floor inside the store and someone falls outside, it's not related to my conduct, regardless if I breached my duty or not. So that's the causation. That's the causation required element. So the damage must be this direct result of the careless conduct. And the test the courts apply here is the but-for test. But for the conduct of the defendant, in other words, because of the conduct of the defendant, or sorry, it's not because, it's but for means if it were not. If it were not for the conduct of the defendant, no injury would have resulted. So the injury only happened because the defendant acted that way. So that's the but for test. That's the physical causation test. Okay? And when someone is injured outside the restaurant, for example, but I was mopping inside, there's this remotedness test. So the remotedness test says that the injury or when I am mopping the floor inside the store, it is foreseeable that someone who comes inside the store may be injured, but it's not foreseeable that someone outside the store would be injured. Or another example, an example that you have in your textbook. So someone bought a bottle of water. There were remains of a dead fly in the bottle of water. Okay, they would be sick. It's foreseeable that someone would be sick, would be injured, but it's not foreseeable that by seeing remains of a dead fly in a water bottle, you would develop mental disorder, anxiety, panic. So that is too remote. That is too far away. So there's still a limitation for this direct cause. Another example would be I have to supply fresh croissants to a coffee shop. I made a mistake. I didn't bring the fresh croissants. I brought something else, or they were in bad quality. My client, yes, was damaged. However, the client of my client also had damage as well. That is too remote. That is too far away. If it's too far away from my conduct, then the remotedness test says that I am not liable. Because if it were like this, if there was no limitation, the defendant would be liable indefinitely for the whole chain of events and etc. So there's a limitation here. So now, we'll look at this in a minute, but I'll just review here. So whenever we sue or we are sued, so the plaintiff, the victim, when they sue for negligence, they have to prove that a duty of care is owned. And I told you, this is usually there, so rarely challenged. Now, they have to prove that the defendant breached their duty. So that's the second required element. And breaching the duty means that the defendant acted below the standard of care. They did not act as a reasonable person would have acted. The plaintiff also has to establish that they suffered damage, injury, loss, and that suffered injury, damage, or loss was physically directly related to the conduct, which is causation. So those four required elements need to be there. If one is missing, and usually what is missing is damage, usually, or loss or injury, then no negligence tort. Is this clear? Can you understand what a negligent tort is?
Yes.
So in real life, sometimes we refer to the term negligent. Sometimes I even tell a friend or family member, hey, don't be negligent. When I say don't be negligent, I mean, or we mean, do not act below the standard of care. Be prudent. When I say don't be negligent, I say be prudent, be diligent, do whatever a reasonable person would do. Because if you are negligent, you may be sued for negligence. Okay, so those are the 4 required elements: duty of care, breach of the duty. Remember, reasonable person is not a perfect person, not an average person, is a similar person to the situation. Then you have the direct result, which is causation, and you have the damage. Okay, even for damage or loss or injury, and even for the direct causation, there's a limitation of the remotedness test. There's also a limitation on those 2 rules, and they are the thin score rule and the crumbling score rule. Well, not the 2 are limitations, but what the thin score rule is. Well, it says that victims are taken as they are. Victims are taken as they are. In other words, it means if you acted carelessly with someone who was more vulnerable to be more injured, they have to be compensated fully, regardless if they were more vulnerable than another person would be. What I'm saying here is, let's say, if I run someone over, not me, but let's say someone is run over on the street and they die. If they are young, they have children, means they have dependents, compensation will be quite high, because there will be compensation for until the children become turn their age of majority. Now, in a similar situation, if someone older without dependents, if they are run over and they pass away, compensation will be lower because they are older, they have no dependents. Now, the fact that the young person was run over, the defendant cannot use as a defense that, they were young. If they were older, compensation would be lower. No, this is not a valid defense. What this thin score rule is saying is that if you cause damages to a young person, in which, let's say, they pass away or they become permanently disabled, you have to be compensated as such. They will be compensated as such. If an older person is injured, they will be compensated as such. So victims are taken as they are, as they are. Let's say you cause injury to the legs of a sports person, and let's say they were very famous. Let's say they made millions per year. Well, you would have to compensate millions per year because they were a sports person. If they were not a sports person, if their legs were injured, but, well, you would compensate not as a sports person. So victims are taken as they are. The injuries they suffered have to be compensated. That's the thin score rule. Now, the crumbling score rule is a limitation to compensation. The crumbling score rule says that if a victim had pre-existing condition, that pre-existing condition does not need to be compensated. So I already had back pain, and then I was hit by a bicycle. My back pain was worsened. Okay, the worsening of my back pain has to be compensated, but my back pain does not need to be healed through compensation because I already had it. In other words, what the crumbling score rule is saying is victims do not need to be put in a better position than they were. No, they will be put in the position they were. And if they already had a pre-existing condition, usually illnesses or any physical condition, that does not need to be compensated. Do those rules make sense?
Yep.
All right. Okay, I see the message here. You lost connection. You are back. That's okay. Thanks for letting me know. And this system captures everything. But thanks for letting me know. So those are limitations for the remotedness test. Now, before we talk about defenses, there are two concepts we need to know. They are misfeasance and nonfeasance. Well, misfeasance is when someone acts wrongfully. They act wrongfully. This is when we act wrongfully. When I share the file without scanning it. When I mop the floor without the wet floor sign. So this is actually acting wrongfully. When this happens, it's usually negligence, and yes, courts will provide a remedy because I acted wrongfully. Now, there are situations in which we fail to prevent an injury. So let's say I see a child playing in the garden, and I prevent to, it's not my child, but it's a child, and I fail to prevent them to be injured. This is known as nonfeasance. I failed to act, and because I failed to act, the child was injured. Well, the law does not require us to save others. The law does not require us to be attentive all the time. No, unless we have a legal obligation, unless we are in a special relationship. So now we can talk about the doctor-patient relationship. Yes, the doctor has a legal obligation to prevent injuries in the patient, as long as they can, as long as their knowledge, experience, and expertise can. Okay, so let's say we are at a swimming pool and someone is drowning. I am not required to save them. And by the way, if I try to save them, I may be even drowned too. Or by trying to save them, I may cause them more harm because I don't have the techniques, I don't have the skills. So that's why the law does not require us to prevent injury in others, unless we have an obligation to. So in a swimming pool, the lifeguard, yes, they have to prevent or do their best, act as a reasonable person, a reasonable lifeguard, to prevent others from drowning. Parents and their children, yes, they have this legal obligation to prevent. Employer and employee. But in general, we don't have this obligation to prevent injury to others. And that's failure to prevent is known as nonfeasance. So nonfeasance will be only remedied by courts in those special relationships, okay? Not in general relationships. Any questions so far?
No, Professor.
All right, so let's look at some defenses to negligence. Well, if you're ever sued for negligence, what defenses can you raise? Well, the most common one is this contributory negligence. This defense is when the defendant was the wrongdoer, the one who acted wrongfully. They say, okay, court, yes, I acted wrongfully and I acted below the standard of care. However, the plaintiff, and the plaintiff is usually the victim or is the victim, the plaintiff also contributed to their loss. How come? Well, if I hit someone that was drunk, it may be that their drunkenness contributed to the extent of their injuries. That is the case of the Sundance ski resort. The competitor was drunk. They rendered quadriplegic. Yes, the ski resort was liable for their injury, but the court said, hey, plaintiff, you were liable to some extent too, because you were drunk and you should not compete in such risky event while intoxicated, while under the influence of alcohol. So this is the court saying, okay, defendant, you are liable, you acted wrongfully, but you plaintiff, you have to bear part of your loss. And then the court will say, hey, defendant, you pay 80%, plaintiff, you bear 20. Or could be 85-15, could be 50-50. Well, whatever the percentage will be, will depend on the specifics of the case. But this is when, again, courts will apportion, will divide, will split evenly or not evenly the loss between the plaintiff, who was the victim, and the defendant, who was the wrongdoer. That's contributory negligence, the most common defense for negligence. Now, there's the defense of voluntary assumption of risk. Well, this is when the defendant is saying that, yes, they acted wrongfully. However, it was because the defendant acted wrongfully. Sorry, the defendant, the plaintiff was acting illegally. No, not illegally, sorry. The defendant voluntarily, not defendant, what is happening to me? The plaintiff assumed their risks. So what the defendant is saying is, okay, I acted wrongfully, but the plaintiff knew about their risks and they assumed their risks. So a simple example would be, my friend was drunk, I was not. My friend was driving. I took a ride with my friend, so I knew he was drunk. So what my friend hits the car, causes me injury. I sue my friend, and then my friend, in his defense, he says, hey, João, hey, court, but João knew I was drunk, so João assumed voluntarily his risk to take a ride with me. Well, courts say, no. João may have assumed the physical risks because, yes, you were drunk and he could be physically injured, but João was not aware of his legal risks. So because knowing the legal risks require some legal knowledge, courts, they say no. In most situations, plaintiffs, they don't know what their legal risks are. So even though they assume their physical risks, they are not assuming their legal risks. So that's why this defense is rarely successful. Rarely successful. It does exist, but it's rarely successful. In an event that, for example, my friend had me sign what is called a waiver. You may have signed waivers when you go to an amusement park, ski resort. I sign waivers for my daughter when she has school activities. So in a waiver, we are saying that, yes, we recognize and we warrant, we agree that the school is not liable if something happens to my daughter or if my daughter does something wrong to others. Well, if my friend in that example had me sign a waiver saying that by taking a ride with him, I would be liable, he would not be liable, then eventually this voluntary assumption of risk would be successful, eventually. But in most situations, the voluntary assumption of risk is not successful. At any rate, if it is successful in this very exceptional circumstances, this defense is successful, it means that the defendant is out of liability, has no liability at all, okay? If it is the case. But again, as I said, rarely the case. So that's voluntary assumption of risk. Now, another defense will be illegality. So I was mixing things here. So now illegality means that the defendant tells the court in their defense that the plaintiff was acting illegally. So the example here is, I'm just looking at my window now and I see the Canada Post employee crossing the street, but not in the crosswalk, so jaywalking. So they are acting illegally. If they are run over, if they are hit by another car, the driver would say, hey, but the plaintiff, the victim, they were illegally crossing the street. Again, this defense is rarely successful. Courts will say, okay, they were wrongful, they were acting illegally. Maybe we will apply contributory negligence because if they had used the crosswalk, eventually you had seen, or injuries would be lower, but no, you are still liable. So even though the victim, the plaintiff, acted illegally, the defendant is still liable because the defendant acted carelessly in a negligent way. So that's why I mentioned to you this defense is rarely successful, very rarely successful, and that's how courts are. We can summarize in a way that courts, they are very much protective of the victims, because even if the victims had assumed their risks voluntarily, so I took a ride with my drunk friend who was a driver because I wanted, I was not forced, voluntarily. Or if I had crossed the street out of the crosswalk, I was acting illegally. But even in those two circumstances, if I am injured, if I suffer any losses, courts will still protect me at some extent. That's why those defenses are rarely successful. All right. Questions, comments?
No, Professor.
Sounds good.
All good so far? Okay, so let's continue. Now we're going to look at some liability and what is the meaning of liability? Can anyone tell me, or can you just Google search just now? What is liability? What is to be liable?
Is to have a future obligation to do something.
Future obligation to do something? Yeah, in those lines?
Legally
what kind of?
responsibility.
Can you say again?
Legally responsible.
Legally responsible. Yes. Okay. So there's a legal responsibility, and that responsibility, which is the responsibility to do something. What is this something usually when you are liable?
Like such as loans or
Okay, loans.
Any
Yes.
other financial obligations.
Yes, financial obligation, and I would say monetary compensation or monetary obligations. So when I say someone is liable, it means that they may end up paying up compensation. So if I say I am liable, it means I have legal obligation to be careful. And if I'm not, to be diligent. And if I'm not, I may have to compensate. So that's what being liable is, what liability is. And why am I asking you this? Because this is something we're going to use now, because we're going to look at occupier's liability, innkeeper's liability, strict liability, product liability. So in other words, what this is saying is, who is liable? Who has legal obligation to pay compensation in case something goes wrong? So we start with occupier's liability. Occupier's liability is written law, comes from statute law, so the Occupier's Liability Act of BC. And the Occupier's liability says that anyone who occupies a property, and it's important to understand this, anyone who occupies the property, because it's not the owner. If the owner doesn't live in the property, if the owner is a landlord, the occupier is the tenant. So it is the tenant that is liable for any injuries, losses, damages that may happen to their guests, their visitors. Now, if the owner lives in the property, then the occupier is the owner. But the key thing here is whoever occupies. Now, when you rent something, if you rent a room, if you rent a house or an apartment, then you are liable for any visitors, any people that come into the property. And you will be liable if anything happens related to the condition of the premises. So let's say the stairs, they were not good, and then someone fell and got injured, or the ceiling just fell on someone's and injured them. Could be any activities in the premises, so people were playing, and by playing, one of them fell and got injured, or they were hit by something, or even the conduct of third parties. If there were more than 2-3 guests, so if one caused harm to the other, you, the occupier, you are liable. Or if you have a service provider, you are also liable because you are the occupier. Now, there's a limitation with regards to a trespasser. You remember that a trespasser is someone that is in our property without our authorization or without legal authorization. So we as occupiers, we are liable to trespassers only if we do something willfully, deliberately, intentionally to harm the trespasser. So if the trespasser falls themselves and are injured, we are not liable in our property. But if we had, let's say, electric fences, or if we had a trap and we did that intentionally to get trespassers, we may be liable for their injury or harm. Again, this is courts being a bit protective to victims of negligence conduct. In this case, is intentional because we would be willfully or recklessly acting against the trespasser. Now, there's also liability for alcohol. In our house or in companies, I know companies that offer alcoholic drinks during the summer barbecue or during the Christmas dinner, company events. So whenever they offer alcohol for free, they become liable. If any drunk employee or you, if you offered alcohol for free in your house in a party, any of your drunk guests that causes harm to others or other property, you may be liable. So offering alcohol attracts liability, similar to the liability of a commercial establishment. When you do so, or when companies do so, they should have people in charge to collect the car keys of people. They should offer rideshare vouchers, taxi vouchers, transportation. They should have people who would not drink and then take care of others. Or in your house or in a company, they can have the bring your own booze parties. So if your guests bring their own drinks, own alcoholic drinks, then you are not liable because they had their own drinks. Okay? So why is this important? This is important because if you offer for free, you attract liability to yourself. And when I say you, I also mean companies, any parties that offer alcohol for free. Okay? So that's very important too. Now, just before we go on a break, innkeeper's liability is similar to occupier's liability, but here, innkeepers, we are talking about hotels, lodging. So here, responsibilities are a little bit broader because they include not only the security of the guests, but also security of their property. Because they are providing a service, housing service or lodging service, they have more responsibilities. So not only the security of their guests, again, and when I say security, I talk about the condition of the premises, also activities on the premises, or even the conduct of third parties. And that extends also to the property of guests, any property they had, any of their belongings. So that's the main difference between the innkeeper's liability to occupier's liability. But basically, liability is very much similar. Whoever is occupying a property, they are liable for any incidents that take place. All right, so let's pause here. Let's have a 10-minute break. Okay, so we talked about negligence. The A, B, C, D, you have to remember, they have to be established for a successful negligence claim. You should also remember about the remotedness test, the thin screw rule and the crumble screw rule. Crumble screw rule. And then the three defenses available: voluntary assumption of risk, contributory negligence, which is the most commonly used, and illegality. So both the first and the third one, voluntary assumption of risk and illegality, they are rarely successful. Now, we just covered occupier's liability, innkeeper's liability. Can you confirm you can see the slides? You're still seeing the slides there?
Yeah, it's
Has it
showing,
moved?
Professor.
Yeah.
It shows.
Okay, so it moved to strict liability now? Okay,
Yeah.
I'll just stop sharing. I'll share again, just to be sure. You're getting it. Yeah, because it was not showing to me. All right, so let's talk about strict liability. Now, there's legal responsibility that is strict. Strict liability means that whoever is strictly liable, it doesn't matter if they were negligent or not. The fact that a damage happened, an injury happened, they are liable. So whoever is strictly liable, it doesn't matter if they were at fault. Now, a good example would be, this is related to dangerous situations, dangerous activities, dangerous products, inherently dangerous products. So for example, let's say I have explosives in my apartment, but they are very well packaged. There's a sign. I have taken all precautions possible, all. It doesn't matter. If they explode and if they cause losses, injuries to others, I am liable. Because whoever has inherently dangerous products, they are strictly liable. Does it make sense? So if you have chemicals in your house, regardless of how well you pack them, you store them, if they leak and go to the neighbor's property and causes losses, you are liable. So that's a strict liability. It is when someone is liable, regardless if they were negligent or not. When they are liable, even without fault. And actually, vicarious liability, which we saw on Monday and we reviewed in the beginning of this lecture, is one type of strict liability. Because if you remember the example, in an employment situation, BCAT, when I cause you loss, BCAT is vicariously liable. But if you think about it, BCAT was not at fault. BCAT was only liable because they are my employer. So that's why vicarious liability is one type of strict liability. Does it make sense? Can you understand this liability without fault? Even if you were very, very diligent, but if that caused loss for inherently dangerous products or activity situations, you may be liable. Is this clear?
Yeah, Professor.
All right. So moving on, we move to product liability. Well, would you agree with me that products may cause losses to us, may cause harm, injuries to ourselves? For those who are not watching Netflix, can you confirm? Can you disagree? Do you agree, disagree? Products can cause harm?
Yeah, and then when they cause harm, usually like when they notice it, it gets recalled.
Okay, so there may be recall. The manufacturers, they may recall, exactly. So can anyone give me an example of a product that can cause harm? Just
Alcohol? Like alcohol?
yeah, any example. Which one?
Alcohol.
I don't think I understand. Can you say that again?
Alcohol.
Oh, alcohol. Okay, alcohol may cause harm,
Higher.
damage. Yes, yes. Even though alcohol is legally sold, but yeah, eventually may cause harm.
Chicken from like a grocery store or like a restaurant. Like if it had like wasn't cooked properly or like it wasn't packaged properly from the grocery store.
Okay. Yeah, that's right. But now, when we go to a restaurant, we eat something, we got sick, we got food poisoning. In principle, we will be suing under contract law because we were in a contract. We purchased the food, and then the food was delivered in poor quality. So when we buy something and then the product causes us harm, we have direct grounds. We have grounds to sue under contract, breach of contract. Eventually, we could sue under product liability, but then we would sue the manufacturer. So let's think about, yes, any packed chicken from a specific company. So we buy the chicken at a grocery store, causes us harm, injury. So we sue. We can sue based on contract the grocery store, but based on product liability, we could sue the manufacturer. And why product liability and not contract? Well, not contract because we didn't buy from the manufacturer. So we can't sue under contract. But because the product was manufactured or packaged by the manufacturer, then we could sue them on the grounds of product liability. Now it's the same thing if you, let's say, if you bring coffee to me. So you buy coffee and you give me coffee. Well, you bought coffee, but if I drink the coffee and I get sick because of the coffee, you cannot sue because you didn't suffer any damages, any injury. I cannot sue under contract because I didn't buy it. It was you who bought it. So my only remedy is to sue under product liability. Does it make sense to you? When there is no contract relationship and the product is defective in a way that causes us harm, we can sue the manufacturer under product liability. And when we sue, we have to prove the manufacturer was negligent. In some circumstances, the judge may order the manufacturer to prove they were not diligent, because sometimes it's difficult for the consumer to be able to prove the manufacturer was diligent. They know the process, they know the ingredients they use, they know the machinery they used, etc. So if they can prove that they were diligent, they may help themselves. But so sometimes courts will allow for will order the manufacturers to prove they were not negligent. Now, if manufacturers, they also fail with the warnings, you know, most products will have warnings. Warnings, if it's a toy, so the warnings are related to the age of the children, because may cause children to swallow, to choke, etc. So if manufacturers fail in the warnings, if they fail to warn some aspect or some characteristics, they may also be sued for negligence. This could also cause them liability under product liability. So is product liability clear? Can you understand when a product causes damages? You may sue under product liability. Important to differentiate when you sue under contract. In other words, when you purchase the product because you are in a contract, or when you are not in a contractual relationship, but still you suffer damages or injury or losses because of a product. Then you sue under product liability. Now, we look at liability of professionals and experts, lawyers, accountants, doctors, dentists, business people, consultants, any professionals you can think of, any experts you can think of. Well, usually they will be causing losses under contract because they are hired. So we hired them, and then they act poorly. They act below the standard of care. So sometimes losses, if the service was of a substandard, lower standard, it's most likely, you most likely will have grounds to sue under breach of contract. However, if they make a mistake, careless conduct, unintentional conduct, they made a mistake, they were typing. So let's say the accountant was preparing the financial statement and they made a mistake. There was a typo in the number. So it was not a substandard service, but it was a mistake. It was a careless conduct. So that could be negligence. And then, in other words, professionals, they are liable for the service they provide, for their conduct. So if a lawyer gives wrong advice, if a lawyer makes a mistake while acting on behalf of the client, this could also be professional liability. Okay, so those are situations in which the lawyer acted, sorry, not the lawyer, the professional in general, the expert in general, when they acted below the standard of care and they have caused damages, losses to their clients. Now, how would you compare the expert? Let's think about a lawyer. How would you compare the lawyer? Remember here when we talked about the reasonable person test? So this is related to whether the breach of duty there was a breach of duty or not. So we applied the reasonable person test. Now, when it comes to a lawyer, for example, who would you compare a lawyer with, whether they breached their duty or not? Would you compare a lawyer with a doctor? Anyone?
No.
No.
Would you compare a lawyer with, I don't know, with a regular person, a person that is not a lawyer?
No.
No, never.
No.
No. So you are right. Professionals, they are compared to another professional in their field, in their area. So whether the lawyer was negligent will be compared to how another lawyer would have acted. Whether a doctor was negligent will be compared to another doctor. How would a prudent, reasonable doctor have acted in that situation? So what I mean is, professionals, well, because they are professionals and because they are experts, first of all, they are held to a higher standard. It's expected that an accountant knows more about accounting than a regular person. So yes, they are held to a higher standard. And not only that, when the reasonable person test is applied, they are compared to another professional in their field. Does it make sense? If the professional is inexperienced, this is not a valid defense. So I told you that I'm not a Canadian licensed lawyer yet. So if I become a Canadian licensed lawyer, and then my first case is a complex one, and then let's say I cause losses to my client because I was negligent, and then in my defense, when my client sues me, in my defense, I raise the fact that I wasn't experienced. This is not a valid defense. And why do we know this? Why should we know this? Well, remember, you are taking this course. I know mostly because it's a required course, but you are taking this course not to become a lawyer, but to think about the legal risk. So with regards to the legal risk, if you are inexperienced, and it's okay to be inexperienced, we are all inexperienced certain moments in our lives, and that's why we're getting trained, experienced, etc. So when we are inexperienced, we either refuse the job or we partner with someone who has more experience, so that we avoid, or at least we do our best to avoid causing losses to our clients, to others. Because if we are negligent, our inexperience will not be a valid defense. Okay, so keep that in mind. Now, professionals, they owe this fiduciary duty. What is a fiduciary duty? Well, this is an enhanced duty, a more sophisticated duty. It is a duty that requires the professional to act with loyalty, good faith, requires the professional or expert not to use confidential information, it's not the not here, to have to disclose pertinent information. So for example, if I have a conflict of interest, if one of my clients wants to sue party A, but I am already a lawyer for party A, so I have to disclose that. Or I have to disclose that I know the party they want to sue, they have filed for bankruptcy, if I know that, because this may affect the enforceability of their award. So that's what this fiduciary duty is. This enhanced duty, this duty that brings those obligations for professionals, for experts with their clients. Again, acting with loyalty, good faith, not using confidential information, having to disclose pertinent information, and also breach of trust. So trust here is more related to money, funds. Sometimes the professional, they will keep funds that belong to the client in their accounts. They will keep on trust so that those funds will be released to whoever they have to in a future moment, in a closing date. This is very common in real estate transactions. Real estate transactions will be, as a buyer, I pay the money to the public notary or to the realtor, and that money is held in trust. In the closing date, when the transaction is closed and I become the owner of the real estate I'm buying, then those funds are released to the seller. Now, if the professional, they use those funds in trust for themselves, they will be breaching the trust. And breach of trust is considered to be a violation, and you become liable for that as a professional. So professionals and experts, they owe this fiduciary duty, and this is important to know, and they also owe a duty of trust in a way that they cannot breach that trust. Now, some professionals, they are required to have professional liability insurance. This is the case for lawyers. When lawyers are called to the bar and they start practicing law, they are required to have liability insurance. I know that financial professionals too. So people or professionals who are involved in advising for investments, etc., they are required to have a professional insurance. So the insurance will protect the professionals for damages they have caused when they make a mistake. In other words, when they are negligent. Insurance will not cover fraud, intentional, or breach of trust. No. Insurance will cover mistakes, errors, omissions, which may happen for a lawyer, for an accountant, for a doctor, when they make a mistake in a procedure, in a drug they prescribe, etc. So some professionals are required to to have to carry professional insurance while they are acting or practicing in that area. Now, we come to the last topic of the lecture, which is insurance. So what is insurance? Insurance is a financial product. It is a product, and parties, the insured, the client, and the insurance company, the insurer, they are in a contract of insurance. So this contract of insurance, or this product called insurance, this financial product called insurance, has the purpose to reduce the cost of loss. So why do we have car insurance? Well, first of all, because it's required by the law. But second of all is because when we suffer a loss, our car, we suffered an accident, or we were involved in an accident, or our car caught fire, or our car was stolen. So those are potential damages, harm we could suffer in the car. We are reducing our cost. Because, for example, I have a Lamborghini that is worth $500,000. When it's damaged, when I suffer a loss, I am reducing my loss because I have insurance. Insurance will cover the $500,000. But I have paid a premium. I paid a premium of $3,000, $4,000, $5,000. So if I have a $500,000 loss, my loss actually will be the premium I paid, not the entire amount of the car, because I have insurance. So insurance allowed me to reduce my loss. Now, if I don't have any losses, any damages, that premium I paid, I don't get back. Every year I have to pay a new premium. And that's the way we reduce our risk. That's the way we mitigate. We transfer our risk to the insurance company. But they only allow to get our risk if we pay them a premium. And they hope we never make a claim. But if we make a claim and we are entitled to coverage, they will have to pay coverage to us. So that's what an insurance contract is, or this insurance contract product is about. Because insurance companies are very powerful. They're big companies in the world. In Canada, they are tightly regulated. There's a lot of legislation, not only federal, but provincial too. For car insurance, specifically in BC, we have ICBC. It is monopoly from the government. But there are other types of insurances. There are extra insurance for cars that we can get from other companies. There's health insurance, there's house, property, etc. So we'll see all types in a minute. Now, with regards to the industry, there are players. Who are the players in the industry? There's the insurance agent. The insurance agent works or represents the insurance company. So when you buy ICBC insurance for your car, you don't usually talk to ICBC directly. You can now. You can do it online. You can renew your insurance. But usually you go to an insurance agent. They represent ICBC and they can sell you insurance for your car. Or sometimes you go to an insurance broker. What is a broker? Well, the broker, they have an independent business and they represent several insurance companies. So they represent ICBC, but they also represent others for other types of insurance, because car insurance will be only with ICBC. Now, both the agents and the broker, they have this duty of good faith to us, customers, clients, but they represent the insurance companies. Now, there's also this insurance adjuster. The insurance adjuster is the one that investigates the loss, the damage, and they negotiate on behalf of the insurance company. So they investigate the damage, the loss, and they come to an amount that the insurance company will pay, will cover. So it shouldn't be a surprise to us that most litigation, most disputes with insurance company, they are related to two things. First, the insurance company is actually denying to pay insurance. So then the beneficiary or the insured, they have to sue the insurance company. Or the insurance company is not denying, but the amount they have paid or they want to pay is much lower than you think you are entitled to. So then you usually sue so that the court assesses that amount. Well, specifically for ICBC insurance, car insurance, so let me show this to you. So ICBC amount dispute. You have to go through arbitration. So if you suffer any losses due to a car accident or any, you're going to make a claim to ICBC and you believe ICBC wants to pay you low. This is not legal advice, but just showing you a real example. You can file a dispute for valuation. So when there's a vehicle damage arbitration, so when there's a dispute with regards to the damage that was caused or the amount that will be paid, you have to start an arbitration proceeding. So you learn about a little bit about arbitration we saw in chapter 3. And if you want to see some previous arbitrations or if you want to learn more, okay, this is a file. Okay, you can read the rules. But actually, if you want to see past, here, previous arbitration decisions. So you can see some decisions here, how they decided the amount they would have paid. And the reasons are here, the arbitrator here. Now, remember I told you that in arbitration, usually decisions are private, not public. But that's not the case for ICBC arbitration. So you can read here. Just got this one as an example. So the award was $500,000 for this situation, and there was an arbitration dispute. Let's just see the end if there was any change. So conclusion. Okay, so the arbitrator decided to decline to reduce the award. So that award, in principle, was maintained. Yeah, but that is just an example. You can read in more details later on. So that's usually that's when an amount is debated about, and that amount comes from this insurance adjuster. Now, moving on here, let's look at some types of insurance. The first one is the liability insurance. We have professional liability insurance, as we just saw, and we have the liability insurance. So businesses, usually they will buy liability insurance because they know they are vicariously liable for the wrongful conduct of their employees. So if they are wrong or their employees are negligent, they will be able to be covered. They will be able to make a claim to their insurance. Liability insurance will not cover willful, deliberate, intentional acts, and they will cover when the insured, the client, is at fault or was at fault. Property insurance. So this is for premises, buildings, and the content. Well, actually, to cover the content, you have to add on. So you add the content protection. And I don't want to advocate for insurance. I don't sell insurance. I have nothing against or for. But we're not talking here about tenancy insurance. But I would say that tenants insurance is very important because if you are renting and uh, let's say there's leaking in your property and it's not your fault, but one of your devices or appliances just caused flooding and flooding in the entire floor and it goes down, mainly if it's in a building, apartment building, it may be that you are liable. Or I don't know, you forgot something in the oven, it caught fire, etc. I know it's cost, but the liability you have, the damages you may cause, they may be very high. And there's also this deductible. So the deductible is the part that we as insured, we pay. So let's say we are covered for, I don't know, 10,000, 50,000, 500,000, but we have to pay a deductible. Usually the strata, if you live in an apartment building, as I do, the strata will have a deductible of $50,000. So sometimes the issue that arose in our unit goes to other units. The strata has to make a claim in their insurance, and they will have to pay this deductible. So in my building, for example, the deductible is $50,000. So because I was the one at fault initially, the strata will come back to me and say, hey, João, you need to pay 50,000. So even though I don't rent, we own the place, but still we have insurance because in case we are required to pay this deductible from the strata, our insurance will cover. And our insurance will also cover any issues in our unit, the contents, etc. So I see here, I've always found insurance to be slimy. Yes, the insurance companies, I know their business is to protect, offer coverage, spread the risk. But I also say that one of their core business is to deny coverage, because what they want the best is or what they want the most is to deny, find any loopholes that you are excluded from coverage. At any sense, yes, they are really good. I agree with you. That's what they do, right, on a regular basis. So at any sense, it's still something we should consider. I'm not saying you have to, you always have to, but well, we never know when damages will be caused, and we may not be able to compensate the damage we cause. So as we saw, for some professionals, insurance is required. The Law Society of BC requires, the financial society or organization, they require, I think for CPA to, well, I don't know the other professions, but it's a requirement because they know damages may happen. And eventually, if you are in business, you may find important. If you are renting or if you own a place, you may also find important to have insurance. And also, well, that's another reason we are going through insurance here, because it may help you decide whether to have an insurance or not, or where to look at, how to be cautious, etc. Another type of insurance is business interruption insurance. So this is on the top of your liability insurance, because the business interruption is used in case your business is interrupted. There was a flooding in the area where you are located, there was fire. So the business interruption insurance will cover all damages you suffered, and also anything that, any costs you will have to be back in business. They will also cover the profits you didn't make. So they will try to put, the coverage aims to put you in the position you would have been if there had been no incidents. But yes, it's an insurance, it's a product, it's more costs to your business. But this is something you should consider. And again, we are always considering whether we face more risks or fewer risks. So you have to assess your own business, your own situation, whether your activity is risky, whether the location you are is risky, etc. And then you make your best call. Life insurance. Well, life insurance, the coverage is paid when the insured, the client passes away, so it goes, the coverage goes to beneficiaries. You can also get life insurance for a key person if you are in business. So I'm going to show you an example later on. There's health insurance, can be used as a medical extra benefits because here in Canada we are covered by the government. And there's also disability insurance if we become disabled, could be temporarily, could be permanently, could be partially disabled or fully disabled. So insurance related to people. Now bonding. Well, bonding exists. The fidelity bond exists because, as you know, liability insurance will not cover willful, deliberate acts. So fidelity bond may. Fidelity bond may cover acts that are willful, that are deliberate. The fidelity bond is a lot used when employee acts wrongfully against the employer. So, for example, when employee steals money or other valuables from their employer. So fidelity bond will cover, but then, the fidelity bond will go after that employee. Now, surety bond. Surety bond is a type of bond that provides coverage if a job is not completed or if the job is not completed on time. This is quite common in public projects with the government, federal, municipal, provincial, because they will hire companies and they want the companies to actually finish the job or finish on time. So the client will usually request the service provider to provide them a surety bond. An individual example, an example on a personal level could be, let's say I bought land, I hire a construction company to have my house built, and I need my house built by June 30th because I have to move July 1st. I'm renting a property. So if they don't complete the job or if they don't complete on time, because I require them to provide me with a surety bond, they would have to pay me compensation. If they don't finish the job or if they don't finish on time. And then that compensation, in my case, I would use for my rent, etc., because I wouldn't be able to move. Now, insurable interest. This is a concept in insurance law, in insurance contracts, and it's important to know. Insurable interest means that we can only buy insurance if we are the one suffering the loss. Now, if there's a loss in my car, I will suffer the loss. So yes, I can buy insurance for my car. In other words, I have an insurable interest in my car. Now, if my daughter suffers a loss, if there's a loss in my daughter's car, she is the one suffering the loss. I am not. So I cannot buy car insurance for my daughter's car. My daughter has to buy car insurance for her own car. Now, it doesn't mean I can't pay. Yes, I can pay. If she doesn't work, I can pay for her, but she's the one buying because she has an insurable interest in her car. So that's what insurable interest is. There's also this example I just told you about life insurance. So Bob and Alice, they are business partners. And if Bob passes away, Alice will suffer some losses because they depend on one another. So Alice depends on Bob for the business. So Alice has an insurable interest in Bob's life. So Alice can buy life insurance for Bob because, again, they are business partners. Now, if Bob is not a business partner of Alice anymore, then Alice would not have an insurable interest in Bob's life anymore. Okay, so this is another example here for insurable interest. Now, I told you that an insurance is based on a contract, so insurance contract. And there's this concept of that is known as contra preferentum rule. So, as we know, insurance companies are very powerful. They have a lot of money. They pay for very good lawyers, etc. So usually their contracts, they will have clauses that favor them, clauses that limit coverage, that expand exclusions, etc. So courts have developed this concept of the contra preferentum rule, which means that if there's any ambiguities in insurance contract, courts will interpret them in favor of the client, in favor of the insured. And if the ambiguity is related to coverage specifically, courts will interpret as much broad as possible because they want to extend coverage as much as they can while interpreting the contract. They will not create coverage. And if courts have to interpret exclusions, limitations, they will interpret them as narrow as possible because they want to limit as much as possible the exclusions for insurance contracts. So even though insurance companies, they are very powerful, we still have some resources and remedies in courts because courts are aware of that and they have developed this contra preferentum rule. But it doesn't mean we shouldn't read the contracts, we shouldn't be aware of what we are agreeing to. Now, this contract of insurance, they are contracts of utmost good faith. And it means that we insured, we client, we must disclose pertinent information and any changes to information. So when we buy life insurance, the insurance company, they ask us if we have any pre-existing illnesses, if we have family illness history, etc. If we lie, coverage may be denied. Or when we buy car insurance, they usually ask us if we are going to use the car for leisure or to work, if there's any driver under 25 years old that drives the car or not. Again, we have to disclose everything that is pertinent. And the insurer, their duty is to process claims fairly and also to arrange legal representation if needed be. Now, question here in the chat, what about accident and sickness insurance? What do you mean by this? So it's usually, we have, if it's an accident by car, so car insurance will cover. If it is a person suffers an accident and they have life insurance, usually life insurance will cover. If they have medical disability insurance, the disability will usually cover sickness. Will cover because the sick person may become disabled, may become temporarily disabled because they are under treatment, or may become permanently disabled. So usually the disability and health insurance in general will cover this.
So the accident and
yes.
sickness would be under the health insurance?
Yes, under health insurance, yes. All right, so contract of utmost. So now subrogation, what does this mean? Well, subrogation means that once the insurance company pays out the coverage, they can step in the shoes of the client and sue whoever they want to sue to recover their losses. So let's see, I have business interruption insurance. My business was under fire, caught fire, and then actually it was fire that originated in the neighbor's property. So I will be covered by business interruption insurance, but then the insurance company, because of the subrogation concept, they can sue the neighbor if they want to recover their losses. I cannot sue because I was already compensated. So I cannot benefit twice from a situation. And the right of salvage. The right of salvage means that the damaged goods that have been compensated, they now belong to the insurance company. So my car was partially destroyed in a car accident. ICBC decided to pay me full compensation for the car, full. Now the damaged car belongs to ICBC. So they can sell as damaged, they can sell the parts, they can do whatever they want. Okay, so that's the right of salvage. It becomes their property. All right. And that's our chapter 7. When we finished the law of torts, so we went through negligence, the A, B, C, D, remember? And then the defense is available. We went through hello?
Professor?
Yes.
Yeah, I have a question. You know that I had also a car accident, but in my case, they are only paying 50% of the damage, not 100%. I don't know why.
Okay, so remember, I cannot give legal advice or comment on personal situations. So I have discussed here what an insurance is, what the contract is about. So now you have to contact the insurance company, understand why they are paying less than what you believe you are entitled to. And again, if you believe you are entitled to more, you should initiate a dispute or you should seek specific legal advice.
Yeah, they told me to appeal. They told me to appeal for it if I want.
Yeah, so that's what I explained here. Remember, I explained that one of the disputes, one of the main reasons for insurance disputes is that the amount that is paid or that will be paid is not the correct amount. So parties, the insured, like yourself, they usually appeal, they usually sue. So I don't know, if your case, it's an appeal, it's a lawsuit, but remember, I'm not teaching you here to decide on your matters, legal matters on your own, but at least to give you some more tools so that you go in more depth and yes, fight for your rights, whether by yourself or whether with legal advice.
Thank you.
But yeah, what you're saying is basically confirming what I said before. Usually insurance companies will not pay what we are entitled to or what we think we are entitled to, and we have to appeal, we have to sue them, and yeah, either the arbitrator or the judge, they will make a decision.
Thank you.
Yeah, welcome. All right, so we went through negligence, the defenses, and then we went through some types of liability: strict liability, occupier's liability, professional liability, product liability, and then we ended now with insurance. Now, how can I know the name of my assignment and when to submit? The name of your assignment. Okay, so there's only one assignment for the course. The details are available under content. And if you want to know who you are partnered with, then you have to go through groups. Okay, so I'll show you. You have on Learning Hub, course page, this one. Okay, so you go under course tools, groups, and you will see your group here. Mine is showing all groups because I'm an instructor. And then if you don't know who your group member is in person, so you can come to this icon here, the message alerts. You can click once, and then you can click on email, and then you will come here and you can start typing the name of the person. So eventually I'll type your name. So Gurleen Singh. So you can just click here, Gurleen Singh, and then you can write an email. Hey, we are a partner for the assignment. Can we start talking? Can we start doing it? Okay. So that's what you do. Okay, so if you don't know who your group member is, again, course tools, groups, then your group will be showing here. You will know who your member is. Okay. Midterm exam, I'll give you details later on. As I said, it's going to be in person. It's going to be at BCAT. But I'll tell you what the classroom will be later on. It's going to be in person. So Wednesday next week. All right. Let me stop here.
Thank you, Professor.